In today's video, we'll start our course with English Legal System, which is our paper 1 of Law 9084. And these are the chapters that we'll be learning in this paper. They are the English legal system and its context, parliamentary law, delegated legislation, statutory interpretation, judicial precedent, and civil courts and civil process, alternative dispute resolution, criminal courts and criminal process, police powers, the judiciary, legal professionals, and lay personnel. Right. We can take these chapters and distribute them in 3 sections that are the blue one. Just a moment. We can say this is section 1, and then this is section 2, and this green one being section 3. In section 1, we will learn all about the principles and the sources of English law. English law refers to the law of England and Wales. So what are the sources and the principles that the English legal system has? We'll be learning in these 5 chapters from 1 to 5. And then the second section we have is the machinery of justice. In this section, we will discuss how the English legal system executes its law and how does it process its law, right? So this is the machinery of justice, how the English legal system carries out, executes its law. And then the last 3 chapters are about the legal personnel. These are about the people involved in the legal industry, the judges, the legal professionals, and the lay personnel that play a role in the legal industry, right? So this is our whole layout for this paper. Right, so after recognizing ourselves with the layout of English legal system, we should know a few things before starting our chapters. That is the definition of law and the classification of law. For the definition of law, it is the system of rules which a particular country or community recognizes as regulating the actions of its members and which it may enforce by the imposition of penalties, right? So law is anything that has been enacted, just a moment, that has been enacted by a legislative body. Right, so you cannot call something law if it hasn't been enacted by a legislature. So it must be enacted by the legislative body in order to be called law. And law mostly defines the rights of people and the duties of people, and it also highlights the sanctions or the damages that the people will be paying if they break the law. So that is, and every country obviously has its law. Without law, no country can exist, I mean. So classification of law is international law, and this is the complete table, right? So let's go through it one by one. The first level we have is international law and national law. Yeah, so international law is a law that deals with foreign relations among countries, and the sources are the treaties by government of the countries, or the agreements or the pacts that are done between them, and that basically provides a framework for how the countries build their relationships over and regulate everything among them. So, and the next is, so national law is law concerned within a state, and national law varies from a country to country and from state to state. Every country has its own law, and that is within the country, within the borders of the country, that law. Right. So in among the international law, we have two classifications, which are public international law and private international law. Public international law is among two countries, right? The law that governs both the countries, and the subjects that mostly concern public international law are national security, organizations among two countries, or human rights, or the waters distribution. Those are the subjects for public international law. And private international law is a bit different from public international law, obviously, because private international law is like, let's call it PIL for now because it's way too long. So PIL mostly concerns of principles and legal guides that regulate private relationships across national waters. Say a Australian comes into contact with someone across the borders with someone in the Britain. So there are more than one jurisdiction involved in the process. There is one country and then there's other country. And if any dispute or some problem arises, then it will the legal guidelines and principles will dictate that what solution should be gathered or which jurisdiction laws should be followed. That is, now if we can go in the depth, that is, conflict of laws is a set of rules or laws a jurisdiction applies to a case, transaction, or other occurrence that has connection to more than one jurisdiction. That is when a person is involved in more than one jurisdiction. When relationships are concerned across the borders. So that is no more, if something is across the borders, that is no more national law. That is, international law, and it's private because private because a private person is involved in it. When a private citizen is a subject to international law. This is basically the shortest definition you can get. Okay, that is it for international law. So when we go further in the classification of national law, we have substantive law and procedural law. Substantive law are laws that are written statutory laws passed by parliament. Those are statutes and acts. They mostly define the rights and the duties of citizen and government. Substantive law is basically written law. And we can take examples such as the Theft Act 1968. Yeah, so Theft Act 1968 is a substantive law. Right, next we have procedural law. Procedural law tackles the steps to process a case, and substantive law is enforced through procedural law. Yeah, so procedural law is basically the mechanism or the steps to process a case. In other words, the rights and the duties provided by the substantive law are processed or enforced through procedural law, right? So let's say a person commits theft or does a crime. The process to further tackle the case, how the police will investigate or how the court will deal with it, that all will be considered in procedural law. Okay, moving on. It is quite procedural law is like the procedure, if you can remember it by that. So, and then following substantive law, we have public law and private law. That are the two classifications of substantive law. Public law is law that deals with function and relationship between state and its citizens. Public law is basically law that deals with that is concerned with the state and its people. So, and concerned with powers and obligations of government and citizens. So that is like, in this law there are both relationship between citizens and state involved. And the further classification of it is as constitutional law, administrative law, and criminal law, because in these three type of laws there is public and citizens both involved. Right, so with constitutional law, we it is those are it considers the principles dealing with the formation of government, its functions, and relations among its organs. Constitutional law basically provides the whole structure of a country. It draws a framework on which the country operates, on which the country operates. It dictates the organs of state. The organs of state are right. So let's say it's a parliamentary system. So we're discussing the English legal system, and it has a parliamentary system. So we'll go through it. Parliament and the executive departments, that is the government, and judiciary. These three are the organs of state, and constitutional law drives the framework for these organs and its functions and its relations among them. Right, so that is for constitutional law. And then we have administrative law. Administrative law deals with the executive branch of government. That is, administrative law basically defines how government deals with public and the other organs of state, that are the judiciary and parliament. And administrative law basically focuses on executing the laws that are being made, right? So that is like the law governing government. So the executive departments, in other words. And the other we have is criminal law. Everyone knows, deals with the crimes against the public or interference with the writ of government. And it is like when someone goes against the law that has been created by the parliament. Okay. Then we have private law. Private law is another word for civil law. Let's write it in a better way. Civil law is equals private law. It's basically the same thing. So private law deals with private matters of people, such as property, divorce, contract, matters that do not concern the state. That is between two people. The matters that are between two individuals or two businesses, or between people or businesses, that has nothing to do with the what we call it, the public, the government. That is private law. And further classifications for private law are, for example, tort law, family law, contract law, company law, property law, employment law. That are pretty self-explanatory. That employment law is the laws that are related to the employment, that is for employees or the employers, all that. Company law and the contract law, the contracts, and family law, divorce, and child custody. Okay, and then tort law, law of negligence. Right. This is basically the classification of law. And if you can understand now, international law, national law, and then following international law, we have public law, public international law, and private international law. And following national law, we have substantive law and procedural law. And following substantive law, we have public law and private law. Following public law, we have constitutional law, administrative law, and criminal law. And following private law, we have tort, family, contract, and so on.